Today is June 25th, and I want to offer you another monthly update of the struggle to bring about a restoration of the Second Amendment rights that should belong to every citizen of Tennessee, but it is not allowed them. The simple reason is the legislature has decided, with its leadership's approval or enforcement, depending on the issue, to deny us those unalienable and indefeasible rights inherited from our ancestors and granted by God regarding carrying arms, dearly purchased by sacrifice of blood and treasure at our founding. Many legislators are beholden to moneyed interests, and never forget money is the mother's milk of all things politic. Many of our legislators are working for those interests, while a few of our elected employees are statesmen. They understand that their oath is to the Constitution, not to the party, not to their donors' will, and not even to their constituents' wishes, if the desires of any of the aforementioned is in contravention to the rules laid out in the contract which is our Constitution. But the majority are not of like mind, and the proof is the fact that since 1801 that body has worked to restrain and choke out the liberty enumerated in our Declaration of Rights regarding arms. There is confusion on the part of the different divisions of government. The judiciary orders the state to allow 18 to 20-year-olds to carry handguns for self-defense or to perfect permits to do the same, specifically calling out Code Sections 1351, 1366, and 1307 in an agreement order signed by our Attorney General. We will see that the legislature failed to heed those instructions. Now, there are members of the General Assembly who think the Attorney General works solely for them. However, Article 1, Section 1 of our Declaration of Rights says that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable and indefeasible right to alter, reform, or abolish the government in such manner as they may think proper. Just as important, Section 2 states that government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. That being said, the legislators work for the people, and even if the Attorney General works for them, he works for us by default, as they are paid servants of the people too, or are supposed to be. And yet, even when the Attorney General agrees with and signs an order of the federal court, the Department of Safety promulgates a rule and the legislature passes a law that directly conflicts with that order. And they do it with brass on their face. Leader William Lamberth passed House Bill 1332 this session that allows only the issuance of permits to 18 to 20 years old under 3917-1351, the Enhanced Carry Permit Statute, not under 1366 concealed carry or 1307G, the so-called constitutional carry, as instructed by the federal court. He will say that I am just never happy with moving in the right direction. But in this instance, I am not happy, as it fails on what the order was and replaces it with what someone with no real authority wants. The reference bill states in Section 2, Tennessee Code Annotated 3917-1351B is amended by deleting the language and substituting under B, except as provided in subsection R, any resident of Tennessee who is a United States citizen or permanent lawful resident, as defined by Section 5550-102, who has reached 18 years of age may apply to the Department of Safety for a handgun carry permit. If the applicant is not prohibited from purchasing or possessing a firearm in the state pursuant to statute 3917-1316 or 3917-1307B, 18 U.S.C. 922G, or any other state or federal law, and the applicant otherwise meets all of the requirements of this section, the department shall issue a permit to the applicant. You know what it does not say? Is that the named subset of people can carry a handgun without a permit. Section 1 of the order says the challenge scheme regulating the possession and carrying of handguns that restricts individuals aged 18 years old to 20 years old from carrying handguns or obtaining permits to carry handguns on the basis of age alone violates the 2nd and 14th Amendments to the United States Constitution. Section 4 of that order, defendant shall implement any and all procedures necessary to accept and review enhanced handgun carry permit applications under Tennessee Code 3917-1351 and concealed handgun carry permit applications under Tennessee Code 3917-1366 submitted by individuals aged 18 years old to 20 years old, and shall not deny issuance of such a permit on the basis of age alone. The order specifies that the age range of 18 to 20 is not a disqualifying factor, as others in the state, 20 plus years old, can carry without a permit. The subset 18 to 20 years old should be able to do so as well. The Second Amendment does not confer any right to any person. It simply chains the government, both federal and state, from infringing the inherent pre-existing right of the people to keep and bear arms. Thank you for your attention, and spread the word.